Thank you everyone for joining. Again, my name is Stephanie Rapp-Tully, and I am a partner in the DC office of Tully Rinckey, PLLC. Today, we are going to be covering the impact of the court's injunction on the executive order Biden administration vaccine mandate. I have been practicing in federal employment my entire career and have been with Tully Rinckey for approximately 7 years. And this has been a subject of main focus this entire year, and particularly since September when the mandate went in place. Today we will be covering the recent Supreme Court ruling on OSHA's emergency temporary standard and the difference between that and what the U.S. Court for the Southern District of Texas did in issuing that injunction. Those two things are very separate, and we'll discuss that. We will discuss how do agency policies change while the injunction is in place, and what happens next, and how this injunction may impact you as a federal employee. So the Supreme Court ruling, which I'm sure everyone heard about, focused on OSHA's mandate. The mandate required all workers for businesses with 100 or more employees to be vaccinated or submit a negative COVID test weekly to enter a workplace. It required all non-vaccinated employees to also wear a mask. The OSHA mandate did not and does not apply to the grand majority of federal employees. However, it would have employed to the Postal Service. And so now that has been, for Postal Service employees, now that has been struck down by the Supreme Court, it is no longer in place. The recent Supreme Court ruling blocked OSHA's emergency temporary standard. Although Congress has indisputably given OSHA the power to regulate occupational dangers, it has not given the agency the power to regulate public health more broadly. It is important to note that it only related to OSHA's emergency temporary standard. If OSHA decides to go through the rulemaking process, which provides for publication, allowing public comment, and then rulemaking, that would be a completely different circumstance. Also, the court noted that if the OSHA changed its requirements or created a different scenario, that would also change it, and that could potentially, OSHA could potentially release a new mandate. In a separate ruling, the court did side with the mandate for the Center of Medicare and Medicaid Services, which requires healthcare workers at facilities that receive Medicare and Medicaid federal funding to be fully vaccinated. So that was a carve out that the Supreme Court made in that decision. So what all of you are here to talk about today is the federal injunction on the Executive Order 14043. The U.S. Court of the Southern District of Texas, Judge Jeffrey Brown, issued an injunction against President Biden's COVID-19 vaccine mandate for the federal workforce. The injunction is a pause that has stopped the implementation of the mandate. The decision cites a case against OSHA that the Supreme Court specifically held that COVID-19 is not a workplace risk, but rather a universal risk that is no different from the day-to-day dangers of all faced from crime, air pollution, or any number of communicable diseases. In the decision, Judge Brown said the question was whether President Biden could require millions of federal employees to undergo a medical procedure as a condition of their employment. That under the current state of the law, as recently expressed by the Supreme Court, is a bridge too far, is what the judge said. He also discussed irreparable harm. He noted that the mandate would meet the legal standard for federal employees facing irreparable harm if they must choose between violating the mandate of doubtful validity or consenting to an unwanted medical procedure that cannot be undone. He did go on to elaborate that while things like lost wages are not necessary to prove irreparable harm, a significant loss in employment opportunity to an individual's chosen field could prove to do so. Some agencies' mandates have predated the executive order, so they were not impacted by the injunction. They have their own policies that will continue to remain in place despite the injunction and are still currently in effect. That includes employees of the Veterans Health Administration, Department of Veteran Health, Health and Human Services Department, specifically HHS Indian Health Service, members of the military, DoD. The injunction does not impact them at all. And the National Institute of Health staffers serving at federal healthcare facilities or clinical research sites. All of these employees and individuals working at these locations or for these agencies were not necessarily subject to the mandate because their agency had done its own mandate that predated the administration's mandate, and the injunction did not cover those requirements. So the change with this injunction, the Safer Federal Workforce Task Force has issued some guidance to help agencies navigate what do we do now. With regards to accommodation and exemption requests, agencies have been given the guidance by the task force to stop processing the current religious exemptions or medical accommodation requests. Agencies have also been advised not to ask employees for any additional information regarding their pending requests or take any other steps to adjudicate those requests. If you are an employee that has a pending request, you may be notified by your agency that due to the injunction, the accommodation exemption is not necessary as long as the injunction is in place. Employees can still submit accommodation exemption requests, and the agency should still accept those requests and hold them in abeyance. The agency, not a part of the injunction, the agency can still collect vaccination information for the purpose of determining who must wear a mask or maintain social distance in the office. That is not included in the injunction and is separate from that. New employees or prospective employees, agencies have been instructed to revise job postings that included vaccination requirements and not enforce those requirements at this time while the injunction is pending. For those with valid offers of employment, the task force guidance tells agencies to reissue those offers to not reference a vaccination requirement. Employees hired while the injunction is active do not have the requirement to be vaccinated, nor do they have to submit for an accommodation or exemption request. It's important to note this is all still while the injunction is in place. If the injunction is ever lifted or reversed, this changes. The continued guidance on the recently issued guidance on disciplinary actions, the task force has told agencies to hold in abeyance all disciplinary actions related to enforcement of the vaccination requirement pursuant to the executive order. Other disciplinary actions can still occur. So if an employee refuses to mask while in a federal workspace, that disciplinary action is separate in part from refusing to be vaccinated or attest to vaccination. So COVID workplace safety protocol violations, masking, social distancing, et cetera, are still in place and can still be enforced, and the agency can still issue disciplinary action. Suspensions related to the executive order halted January 21st, 2021. Employees should be restored to pay status. Any proposed or active disciplinary action related to the enforcement of the executive order is currently enjoined, and that disciplinary action is held in abeyance while this injunction is in place. Disciplinary actions that have already occurred need not be repealed, rescinded, or revoked. This could include a letter of education or counseling, letters of reprimand, proposals of a suspension that may be stored in an employee's personnel file. So what comes next? As I've stated, the injunction does not mean the executive order has been declared unconstitutional or has been overruled. That is yet to be decided. An injunction is temporary. The Justice Department has already filed the appeal of the injunction to the Fifth Circuit Court, and I imagine it'll go to the Supreme Court from the Fifth Circuit, just like the OSHA ruling did. Those who were in the process of completing your accommodation request for religious or medical purposes should continue to do so. There is no harm in filing those requests. They just cannot be adjudicated or reviewed at this time. Prior to the injunction, no federal agency could take a disciplinary action for failing to comply with the mandate so long as the employee had a pending accommodation request. The previous guidance to employees was that the agencies were directed to initiate an enforcement process to work with employees to encourage compliance, and that period of education and counseling was 5 days. If employees did not demonstrate progress in becoming vaccinated, disciplinary actions could follow, including 14 days suspension or less suspension, and continued noncompliance could be followed with a proposed removal from employment. If employees started to demonstrate progress of being fully vaccinated, agencies were directed to hold off discipline towards that employee and grant reasonable time to become vaccinated. That is true also, as I said, for putting in an accommodation request or an exemption request. If there are any additional questions, I'm happy to take them now. As always, if you are seeking more detailed information and want to talk to me or any of my colleagues directly, feel free to reach out to us. This is a very nuanced situation, and there can be a lot of variables in a person's situation. So we're happy to talk to anyone who has specific questions to their own situation. Thank you. The question I got was any idea how long the appeal process might take or to get to the Supreme Court? This process does tend to move pretty quickly. We saw that with the OSHA case. It moved very quickly from the district court level to the circuit level to the Supreme Court. I imagine that that will be the case as well. I think it'll eventually go to the Supreme Court to make a decision. However, there might be, if the circuit court reverses, brings it back down, there would have to be additional litigation. So an exact time frame is hard to estimate. Someone asked if the injunction covers the DC government. The DC government is its own entity, just like the Alabama state government. So it would be a different process and a different standard review and would not be applicable to the federal injunction. Someone asked if the injunction covers NOAA and the Department of Commerce. I believe so. The ones we listed are the ones we understand to be to have additional requirements that predated the mandate. And so those agencies do appear to be under the injunction. Of course, if you have a specific question as to whether the injunction applies to you, I would contact your agency, particularly the HR representative, and ask that question. If they had identified a specific group to send exemption requests, that might be a great place to start with those individuals. Someone asked, when I was referring to DoD military, did that include federal DoD employees or only service members? So federal DoD employees would be under the injunction and under the mandate. Those are civilians. Service members are have different requirements and are not subject to this injunction. And as far as I'm aware, their mandate is still ongoing. So someone asked if they already have an EEO complaint pending for religious discrimination, if this has any impact on that. I think that's a very interesting question. The agency can no longer enforce it. So if the agency has already taken disciplinary action against an individual on the basis of not not giving a religious exemption, so it'd be a religious discrimination case, then there is the potential. The case would still continue. It just would be a question as to whether it would be, what would be the ultimate outcome if the injunction is in place. Someone asked, again, is the mandate over? Is this just temporary? This is just temporary. The injunction is not a finding that the mandate is unconstitutional or unlawful or has been struck down as a matter of law. This is a temporary stop to the enforcement of the mandate. Someone asked about the relationship between the OSHA Supreme Court case and this injunction. There is a crossover in that the subject matters are the same. Obviously, the COVID vaccine is the topic in both. However, it'll come down to authority. OSHA's authority over the private sector is a different analysis than the federal government's authority over federal employees. So there will be an overlap in discussion of it, but the standard of review would be different, or not the standard of review, the authority being reviewed would be different as to whether the federal government can make these requirements for all of its employees. And again, it comes down to that irreparable harm point that Judge Brown did mention. That will need to be reviewed. There's a question, I've seen a couple questions about testing requirements. As I stated earlier, testing requirements are not covered under this injunction. In terms of being able to be on site. So if the agency has a testing requirement to be able to step into a federal workspace, that has not stopped. That enforcement has not stopped. I don't know if there's any pending legal oversight on that specific component of it. But as far as I'm aware, the injunction did not cover that. And so if there is that requirement, I believe agencies would likely still enforce it. A lot of this is, to a certain extent, agency dependent. The mandates set the floor of what agencies had to do, and the agencies could do more. So an agency, like we saw with the Department of Veterans Affairs, could do more. Department of Health and Human Services can do more. So it's really important to look at what's coming from your agency and assess what are they requiring. Someone asked if this, since this is temporary, do you know what the next step is and the likelihood it'll be permanent? So like I said, it's being challenged in court. The Department of Justice has already filed that appeal. That appeal will need to be litigated. If the appeal comes down in favor of the federal government, then the injunction will be lifted. If not, and the injunction is enforced, it'll likely be that the federal government appeals to the Supreme Court, just as the OSHA case, same trajectory as the OSHA case. So someone asked about testing for only unvaccinated employees. Again, that relates back to what I was talking about in terms of the agency's individual requirements. If their safety protocols for COVID include testing for individuals who have not identified as being vaccinated, I don't believe that the injunction has had any impact on that. I'm seeing a bunch of questions about whether if someone's exemption request was already denied, then, so if someone's exemption request was already denied prior to the date of the injunction, what should they do? And I think that depends on what has happened since the denial. If the employee has faced disciplinary action, you know, it matters where you go in terms of avenue, but certainly there could be, if it was denied on the base and you were alleging a religious exemption, certainly there could be an argument of religious discrimination. That would be something that I would recommend talking to us about, attorneys about, and to help you navigate where's the best place to bring any sort of action depending on what has occurred. Someone asked, does the Fifth Circuit have to take up the appeal? Yes. It's really only the Supreme Court who gets to say we're taking this or we're not, and grant cert. So yes, and it is an active case. So if an agency still has that language on job sites or job postings, they should be rescinding that post and reissuing. It really comes down to enforcement of it. They cannot enforce it currently. So if a job posting says you must be vaccinated and show proof of vaccination, they can't enforce it right now. So you cannot be denied a position solely based on the vaccination status. That would go contrary to the injunction. A number of people are asking really specific questions about their situation. I'm not going to be covering people's specific situations. I would highly recommend giving our office a call to discuss those more in depth, but I'm not going to cover anyone's individual circumstance. I'm just answering general questions about the injunction. Someone asked if the Fifth Circuit overturns the injunction, can the plaintiff appeal? So if the Fifth Circuit overturns the injunction, it goes back down to the district court, at which point it could go back up. With cases like this, there's a lot of up and down in terms of district court, circuit court, Supreme Court, depending on specifically what the decision says. Sometimes decisions specifically say what should happen to the case to proceed to trial, to proceed for further litigation. It will specifically say. So since that hasn't happened yet, it's hard to say what the decision will actually say. But if the injunction is lifted, it will go back down most likely. And then at that point, it is important to note there will not be an injunction in place, and that will change what agencies could currently do at that time. Someone asked, will there be more webinars on this topic? I imagine so. This has been a topic I've spent a lot of time this year talking about because it's ever changing. I imagine that this entire process will not be over for at least a year or two, possibly longer. And I imagine that we will go through various waves of what is required, what isn't required. So will there be more discussions on this, additional webinars? I imagine, and a particularly poignant time would be if and when there is a Fifth Circuit decision. I'm sure we can have a webinar to discuss that decision and the impact on federal employees. And then if it's going up to the Supreme Court or if it's going back down. Someone asked, how long does the injunction last? The injunction lasts until there's a decision that says otherwise. It's temporary though, so it is not permanent, as I've said. It does not strike down the law, the mandate, or the executive order, I should say, does not strike it down as unconstitutional or not law, nor has the court said that it's very specific to the language of the mandate, not the administration's ability to issue executive orders. Yes, I do believe that it'll ultimately go to the Supreme Court. I'm not sure how it will get there, if it'll be, if the Fifth Circuit strikes it back down, it's going back down. But I imagine at some point we get up to the Supreme Court. I've seen a number of questions, a lot of questions actually, about class action lawsuits or joining a lawsuit. That would be a very specific question that I would recommend having a private call on. That's specific to your situation and not something general that we can talk about. So that would be something that I would recommend contacting the law office for. And just because I'm not answering a question right now, first of all, some of them, they just come in very fast. So if I missed your question, I do apologize. But But just because I'm not answering your question doesn't mean we can't answer it. Sometimes a lot of the questions I'm seeing are very specific, and I don't want to get into anyone's specific work situation here in this forum. However, I'm happy to talk to anyone individually. Someone asked if our law office charges for an initial consultation. We do. Please contact our office for that consultation fee price, and we're happy to get you set up. As far as someone just asked if there's a date for the Fifth Circuit to hear the case, I am not aware that there has been an oral argument scheduled in the case yet. I'm sure we will find that out very soon since the appeal has been filed already. Normal appeal process is that the petitioner, person appealing, appellant sometimes called, has to file a brief, and then the respondent responds. And then the briefs go to the court to either review on brief, which means no oral argument, or to have an oral argument. I imagine this will require an oral argument, but I don't know. That's up to the court. At that point, I'm sure they would notify. It would be newsworthy to that oral argument. So I'm sure everyone will get notified through the news about when that oral argument is scheduled, when it is scheduled. All right, I think we're going to wind down questions. So if you have any last minute questions, send them in now. Otherwise, we're going to wind down. I thank everyone for your time today. I hope this has been educational and helpful to you. And again, if anyone has any specific questions that they want to go over, please contact the law office so we can schedule a time to talk with you. Someone asked, what happens if the injunction is overturned and the mandate is back on and individuals are forced to get vaccinated, and then later the mandate is overturned? Whether there's a course of action there, I think that's a very, believe it or not, that's a very complicated question. Usually the law that is in place at the time of the action is what is controlling, not what happens to it after the fact or what had happened before. It is the law at which the time is the action is taken. You know, it really would depend on the court's decision and then the subsequent court's decision in this question and what the guidance is after those decisions from the court. I think those are all of our questions, at least that I have seen. Again, if I didn't answer your question, please feel free to contact us. I'm happy to do so. But thank you all again for joining us today. And I'm sure we will have the opportunity to have another webinar once there are more developments on this. Thank you, and everyone have a pleasant afternoon. Really appreciate it.